Hey guys, so in this video, we'll be under criminal procedure and we'll discuss Rule 110 or prosecution of criminal offenses. So let's begin. So what is the purpose of a criminal action? Remember that the purpose of a criminal action is to determine the penal liability of the accused for having outraged the state with his crime and, if he be found guilty, to punish him for it. In this sense, the parties to the action are the people of the Philippines and the accused. The offended party is regarded merely as a witness for the state. So we often come across this sa mga cases, diba? It's people of the Philippines versus Santos or people of the Philippines versus Reyes. So, yun. So, how are criminal actions instituted? So, step one now is to determine first whether a preliminary investigation is required. So, the institution of a criminal action generally depends upon whether or not the offense is one which requires a preliminary investigation. So, under Rule 112, Section 1, a preliminary investigation is to be conducted for offenses where the penalty prescribed by law is at least 4 years, 2 months, and 1 day. So, after determining whether a preliminary investigation is required or not, you can now determine where, before what office, the criminal action should be filed. So the step 2 naman daw is filing of the criminal complaint. So for this, you need to make distinction whether a preliminary investigation is required or not and whether the offense was committed in Manila or in a chartered city or not. So where a preliminary investigation is required, so a criminal action now is instituted by filing the complaint with the proper office for the purpose of conducting the requisite preliminary investigation. Sino ba tong proper officer na sinasabi dito? Remember the rules on jurisdiction of the investigative agencies. So yung mga ito, yung sasabihin kong sunod, ito yung mga officers na pwedeng mag-conduct ng preliminary investigation depending on the crime. First is the Office of the Prosecutor under the Department of Justice, and second is the Ombudsman. So, third, pwede rin yung COMELEC, but note that prior to August 2005, the municipal trial courts and the municipal city judges can conduct preliminary investigation, but that power is now withdrawn. So, kailan naman hindi required yung preliminary investigation? So, Metro Manila and other chartered cities, the complaint shall be filed with the Office of the Prosecutor unless otherwise provided in their charters. So, by other areas, by filing the complaint or information directly with the municipal trial court and municipal circuit trial court, or by filing the complaint with the Office of the Prosecutor. So next naman, place or territory where the criminal action is to be instituted. You try to look at section 15 of Rule 110, yung discussion dyan on jurisdiction over the territory. So this pertains not to the institution of the criminal actions through a complaint, but rather the actual filing of the information once a complaint is filed and the case is ready to be filed in court. So what rule is to be followed here? The criminal action shall be instituted and tried in the court of the municipality or territory where either 1, the offense was committed, or 2, where any of its essential ingredients occurred. So ano yung exception dito? Where an offense is committed in a train, aircraft, or other public or private vehicle in the course of its trip, the criminal action shall be instituted and tried in the court of any municipality or territory where such train, aircraft, or other vehicle passed during its trip, including the place of its departure and arrival. Pangalawang exception, where an offense is committed on board a vessel in the course of its voyage. So the criminal action shall be instituted and tried in the court of the first port of entry or of any municipality or territory where the vessel passed during such voyage, subject to the generally accepted principles of international law. Pangatlong exception is crimes committed outside the Philippines but punishable under Article 2 of the Revised Penal Code. It shall be cognizable by the court where the criminal action is first filed. And fourth, other special laws such as Article 360 of the Revised Penal Code and Human Security Act. We go now to who can institute criminal actions. So for public crimes now, it's anyone can institute. While private crimes, such as yung kung naalala natin from our criminal law 2, yung adultery, concubinage, ganyan, only the offended party here or the specified persons can institute. So, yun na nga yung sinabi ko, sa adultery and concubinage, it must be the offended spouse and must impede both the offending spouse and his or her paramour. Pangalawa, yung abduction, seduction, acts of lasciviousness, it must be the offended party or her parents, grandparents, guardian, or the state, in that order, if she is a minor. To defamation cases, which consist in the imputation of any of the offenses above, it must be by the offended party. Note that minors can initiate the action themselves, especially if the offender is their relative, except when incompetent or incapacitated, in which case the parents, grandparents, or guardian may file the same. What are the factors to consider in the prescription of crimes? First is how long is the prescriptive period? Second is when the prescription commences. Third is when prescription is suspended. And fourth is how prescription is interrupted. So we'll discuss this one by one. So one of the ways of how criminal liability is extinguished is through prescription. Prescription of felonies under the RPC is governed by Article 90, and the prescription of criminal offenses under special laws is governed by Act number 3326 in the absence of provisions of such special laws. So yung period of prescription for felonies under the revised penal code, it depends on the maximum imposable penalty of the felony involved. So we have afflictive penalties, 15 years para mag-prescribe. Correctional penalties, except arresto mayor, is 10 years. When the penalty is arresto mayor, it's 5 years. When it's libel and other similar offenses, it's 1 year. Oral defamation and slander by deed is 6 months, and light penalties prescribes in 2 months. On the other hand, for criminal offenses punished under special laws, we apply the proper prescriptive period under the special law concerned. In the absence thereof, Act number 3326 governs. Offenses punished only by a fine or by imprisonment for not more than 1 month or both prescribes in 1 year. Offenses punished by imprisonment for more than 1 month but less than 2 years prescribes in 4 years. Offenses punished by imprisonment for 2 years or more but less than 6 years prescribes in 8 years. While offenses punished by imprisonments for 6 years or more prescribes in 12 years. For treason, it prescribes in 20 years, and violations penalized by municipal ordinances, it prescribes in only 2 months. So the commencement of the prescription naman, let's go there. So felonies under the revised penal code, for all criminal offenses, the period of prescription shall commence to run from the day which the crime is discovered by the offended party, by the authorities, or by their agents. Yung Article 91 provides that criminal offenses punished by special laws, it's not in the RPC pala, but on the other hand, dito sa special laws, prescription shall begin to run from the day of the commission of the violation of the law, and if the same be not known at the time, from the discovery thereof. Ano yung exception dito? Naging exam namin this is yung subject which I forget yung doctrine nito, but you should remember by heart. It's the blameless ignorance doctrine. So this blameless ignorance doctrine is incorporated in Section 2 of Act 3326. Under this doctrine, the statute of limitations runs only upon the discovery of the fact of the invasion of a right which will support a cause of action. In other words, the courts would decline to apply the statute of limitations where the plaintiff does not know or has no reasonable means of knowing the existence of a cause of action. Thus, it was held in the contenda of cases that if the violation of the special law was not known at the time of its commission, the prescription begins to run only from the discovery thereof. So, ayun. So, paano naman nasususpend itong prescription other than interruption? So, sa felonies under the revised penal code, the term of prescription shall not run when the offender is absent from the Philippine archipelago, while criminal offenses punished by special laws, no similar provision like the RPC. Wala nga daw ganon. So note that the running of the prescription of an offense punished by a special law is not told by the absence of the offender from the Philippine soil. How about interruption of the prescriptive period? So the rule here is any kind of investigative proceeding, whether executive or judicial, instituted against the accused, which may ultimately lead to his prosecution, is sufficient to interrupt the running of the prescription. So this rule covers both offenses under the RPC and special penal laws which do not provide for their own rules. So when does the prescription run again after it has been interrupted? It commences to run again when such proceedings terminate without the accused being convicted or acquitted, or are unjustifiably stopped for any reason not imputable to him. Is the prescription interrupted even if the court where the action is later filed is without jurisdiction? So the answer here is yes. The running of the prescriptive period is interrupted with the filing of the action even if the court in which the action was first filed is without jurisdiction. Yung cat ko. So anyway, who must prosecute the criminal action? So the rule is that a criminal action is prosecuted under the direction and control of the public prosecutor. So the rationale for this rule is that this is because a criminal offense is an outrage against the sovereignty of the state. It necessarily follows that a representative of the state shall direct and control the prosecution thereof. It is a cardinal principle that criminal actions, either commenced by complaint or by information, shall be prosecuted under the direction and control of the fiscal. The institution of a criminal action depends upon the sound discretion of the fiscal. He may or may not file the complaint or information, follow or not follow that presented by the offended party, according to whether the evidence in his opinion is sufficient or not to establish the guilt of the accused beyond reasonable doubt. So the reason for placing the criminal prosecution under the direction and control of the fiscal is to prevent malicious or unfounded prosecution by private persons. It cannot be controlled by the complaint. Prosecuting officers under the power vested in them by law not only have the authority but also the duty of prosecuting persons who, according to the evidence received by the complainant, are shown to be guilty of a crime committed within the jurisdiction of their office. So they have equally the legal duty not to prosecute when, after an investigation, they become convinced that the evidence adduced is not sufficient to establish a prima facie case. So even if there is a private prosecutor, the criminal action is still prosecuted under the direction and the control of the public prosecution. The private prosecutor is the counsel of the offended party. So ano nga pala ulit yung duties ng public prosecutor? First, it's to conduct preliminary investigation. Second, it's to prosecute a case. Ano naman yung what if naman the public prosecutor is absent in the prosecution of the criminal action? The criminal action cannot proceed. The private prosecutor cannot proceed with the trial of the case. The hearing will be cancelled, and if the hearing continues despite his absence, the proceedings will be considered null and void. But the public prosecutor may turn over the actual prosecution of the criminal case to the private prosecutor in the exercise of his discretion, but he may at any time take over the actual conduct of the trial. In this case, the public prosecutor still has direction and control of the case and must still be present during the hearing. So ano naman yung exceptions? So when the private prosecutor is authorized by writing to do so. So a private prosecutor may prosecute the criminal action up to the end of the trial, even in the absence of the public prosecutor, if he is authorized to do so in writing. A written authorization shall be given by either the chief of the prosecution office or the regional state prosecutor. The authorization, however, must be approved by the court. The written authorization may be given either because the public prosecutor has a heavy work schedule or there is a lack of public prosecutors. Pero yung authority na to, pwedeng ma-revoke or ma-withdraw. So while generally, a criminal action in a municipal trial court shall also be prosecuted by the public prosecutor in his direction and control. However, when the prosecutor assigned is not available, the action may be prosecuted by the offended party, any peace officer, or public officer charged with the enforcement of the law violated. So we go now to the intervention of the offended party or the appearance of a private prosecutor. So the rule here is where the civil action for recovery of civil liability is instituted in the criminal action. The offended party may intervene by counsel in the prosecution of the offense. Generally, the institution of the criminal action carries with it the institution of the civil action. The appointment of a private prosecutor is done by the offended party and is the mode by which the latter intervenes in the prosecution of the offense. A fundamental principle in criminal law is the rule that every person criminally liable is also, for a felony, is also civilly liable. This is Article 100 of the RPC. Thus, generally, a person convicted of a crime is both criminally and civilly liable. It is because of the existence of the civil liability involved in a crime that the offended party is allowed to intervene in the prosecution of the offense. May exception ba dito? So the exceptions are when the offended party waives the civil action, reserves the right to institute it separately, and institute the civil action prior to the criminal action. Ito yung tatlong exceptions. So we go now to the prosecution of criminal cases on appeal. So the rule is that in criminal proceedings on appeal in the Court of Appeals or in the Supreme Court, the authority to represent the people is vested solely in the Solicitor General. The exception here is that all cases elevated to the Sandigan Bayan or from the Sandigan Bayan to the Supreme Court, the Office of the Ombudsman, through its special prosecutor, shall represent the people of the Philippines. How about prosecution of private crimes? So the rule is that in private crimes, the prosecution cannot prosecute a criminal action where no complaint is filed by the proper party. Na-mention na natin kanina, di ba, sa private crimes, sa adultery and concubinage, sa mga seduction, ganyan. So, kailangan nga daw, yung offended spouse yung mag-file nito. It must be instituted against both parties. Kung wari sa adultery and concubinage, seduction naman, it must be the offended party, yung parents niya, or yung grandparents, or yung guardian. So, yung exception naman dito is if the offended party dies or becomes incapacitated before she can file the complaint and she has no known parents, grandparents, or guardian. And so here, the state shall initiate the criminal action in her behalf. How about prosecution of criminal cases by special agencies under special laws? So the rule here now is that the prosecution for violation of special laws shall be governed by the provisions thereof. For instance, a criminal charge for violation of the Securities Regulation Code is a specialized dispute. Hence, by law, it must be first referred to an administrative agency of special competence, which is the Securities and Exchange Commission. We go now to the complaint and the information. First, what we discuss what is a complaint. So a complaint is a sworn written statement charging a person with an offense prescribed by the offended party, any peace officer, or other public officer charged with the enforcement of the law violated. It is not a mere statement. It is a statement charging a person with an offense. As a statement, it must be sworn and written. It is subscribed only by any of the following persons. First is that the offended party. Second, any peace officers. Third is other public officers charged with the enforcement of the law violated. So what is an information naman? An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. While an information is an accusation in writing, it is not required to be sworn, unlike a complaint. This is because the prosecutor filing the information is acting under the oath of his office. Only a public officer described by the rules as a prosecutor is authorized to subscribe to the information. What if there is an infirmity in the signature or authority of the prosecutor? So the information must be signed and authorized by the head of the prosecution office and not merely the assistant prosecutor. If it is not properly authorized, this is a ground to quash the information. So in whose name is an information filed? The complaint and information are not filed in the name of a private person. It is filed under the name of the people of the Philippines and is filed against all persons who appear, to be responsible for the offense involved. So the private offended party have limited roles in criminal cases. They are only witnesses for the prosecution. Paano naman natin masasabi na sufficient yung laman ng information? So a complaint or information is deemed sufficient if it contains the following. First, the name of the accused. If the offense is committed by more than one person, all of them shall be included in the complaint or information. Second is the designation of the offense given by the statute. Third is the acts or omissions complained of as constituting the offense. Fourth, the name of the offended party. Fifth, the approximate date of the commission of the offense and the place where the offense was committed. We have a test here. The test is whether the crime is described in the intelligible terms with such particularity as to apprise the accused with reasonable certainty of the offense charge as to enable the accused to adequately prepare for his defense. Kasi against the Constitution naman din, against the Constitution naman din, kung hindi adequate yung information, hindi niya kasi alam paano dedepensahan yung sarili niya. So how does the accused question the insufficiency of the information? He must file a motion to quash, otherwise the defect is deemed waived. So yun na nga. We go now to amendment versus substitution. So first, when is amendment proper? Where the second information involves the same offense or an offense which necessarily includes or is necessarily included in the first information, an amendment of the information is sufficient. When is substitution proper? Where the new information charges an offense which is distinct and different from that initially charged, a substitution is the proper course. So the test here is there is identity between the two offenses when the evidence to support the conviction for one offense would be sufficient to warrant a conviction for the other, or when the second offense is exactly the same as the first, or when the second offense is an attempt to commit or a frustration, sorry, of when it necessarily included the offense charged in the first information. So how is an amendment of the information done? An amendment is the correction of an error or an omission in a complaint or in an information. Um, rule Section 1 of Rule 110 of the Rules on Civil Procedure on how it is done. We should look into that. So when amendment of the information is allowed, first, we have amendment before the plea. We have formal and substantial amendments. It is allowed without need for leave of court, except leave of court is required, which must be obtained by motion for the prosecutor, which with notice to the offended party, if either the amendment downgrades the nature of the offense charged or the amendment excludes any accused from the complaint of the or information. How about amendment after the plea? So we have formal amendments pa rin and substantial amendments. For formal amendments, it is allowed after the plea, but only if leave of court is secured. The amendment does not cause prejudice to the rights of the accused. And substantial amendments is not allowed anymore after the plea. So how do you determine whether an amendment is formal or substantial? The test here is as to whether defendant is prejudiced by the amendment or whether the amendment changes the nature of the crime or affects the essence of the offense. Second, whether a defense under the information as it originally stood would be available after the amendment is made. And third, whether any evidence the defendant might have would be equally applicable to the information in one as in the other. When substitution naman of the information proper. So distinguish substitution from amendment as we did a while ago. Na an information may be substituted if it appears at any time before judgment that a mistake has been made in charging the proper offense. In such the case, the court shall dismiss the original complaint or information once the new one charging the proper offense is filed, provided the accused will not be placed in double jeopardy. So kailangan mo dismiss muna yung other case. The dismissal of the original complaint or information is subject to the provisions of Section 19 of Rule 119. Under this provision, if it becomes manifest at any time before judgment that the accused cannot be convicted of the offense charged or of any other offenses necessarily included therein, as when a mistake has been made in charging the proper offense, the following rules shall be observed. First, the court shall commit the accused to answer for the proper offense by requiring the filing of a proper information. Second, the accused shall not be discharged if there appears good cause to detain him. And third, after the proper information is filed, the court shall dismiss the original case. So there we go for Rule 110. Thank you for listening, and I'm sorry if my cat was kind of kulit. But I hope you learned something for criminal procedure. Thank you.